That I wanted to make sure that we thanked our sponsors. As you know, the Canadian Taxpayers Federation sponsored our reception last night, for which we were very grateful. And we also have some other sponsors. McCaig Borlaug has been a generous sponsor of this conference, as well as Dr. Roy Epen, who is over there, and James Jones, and several anonymous donors. So our thanks very much to all of you for making this happen. Okay, without too much further ado, I'm very, very pleased about our keynote speaker today. Our keynote is Clark Neily, who is a senior attorney at the Institute for Justice. IJ, as we like to call it, is a libertarian public interest litigation firm based in Washington, D.C. They do in some ways a lot of what the CCF does, but on a scale of magnitude vastly larger, a lot more attorneys. And Clark, I worked with Clark at IJ. I was only there for about 2 years, but that was my first job out of law school. So in 2000, we were both there at the same time. I was fresh out of law school, not really knowing how the actual practice of law worked. Clark had been a litigator for several years before, even though he was new at IJ. And I remember being struck very, very early on of how Clark was both passionate about the ideas, about freedom, a smart attorney, but also a really good litigator, which in my mind, the two had sort of been separate. You'd either be really into the cause or you'd be a good litigator. So it was quite eye-opening and refreshing to meet Clark and to see, and certainly he has continued that way apace in the past 15 years. He's now the director of IJ's Center for Judicial Engagement, which I think would be of a lot of interest to most of you here. It was created to challenge the unconstitutional expansion of government by articulating a principled vision of judicial review. So it really gets into a lot of the questions that we've been examining about what is judicial activism, what's going too far, how engaged does the judiciary have to be to actually protect our rights. Clark's going to talk about that. He also has a great book that I meant to plug here. Anyway, that you can order on Amazon. But for now, I'm just going to turn it over to Clark. And thanks very much for coming.
Thank you. It's really a pleasure to be here. I've enjoyed getting to meet some of you and talk to you. And I want to apologize in advance. I have to run out the door as soon as I get done. I have an 8-month pregnant wife at home, and she's eager to get me back home where I can drive her to the hospital if necessary. So I won't have the chance to get to know the rest of you, and I regret that. But I do really want to thank Marty and her colleagues for the opportunity to come and speak to you. What I was going to talk to you about is the idea of unenumerated rights and judicial engagement. The first term hopefully is familiar to most of you. It's the idea of rights that are not explicitly articulated or identified in a constitution or a charter. The other term is probably unfamiliar because we invented it a few years ago at IJ. But judicial engagement is, in a nutshell, the idea that there should be real judging, real conscientious judging in all constitutional cases, and not just a handful of constitutional cases, which is how we do it in America. And so I guess in some ways, the talk I'm going to give you today is sort of a cautionary tale of what not to do based on what we do in the United States. I want to return the compliment to Marnie. I've only worked with 2 Canadian lawyers. The first is Marnie, and the second is a colleague of mine named Jeff Rose, who's from Alberta, went to Harvard Law School, clerked for a couple of American judges. And I'll tell a quick anecdote about Jeff. He had never appeared in court before. He was a brand new baby lawyer, and he shows up at the Institute for Justice, and one of the first things he does, he'd been there a couple of weeks, and he identifies this federal appellate court decision from the Sixth Circuit Court of Appeals, actually right across the lake, covers Michigan, Ohio, and a couple of other states. And Jeff decides, in his infinite wisdom as a newly minted lawyer, that the appellate court has gotten an important constitutional issue wrong, specifically a free speech issue. There was a somewhat crazy law in a town in Ohio where if you had a car parked on the street, you could put any sign you wanted to in that car, in the back window of the car, go Buckeyes, Obama sucks, Obama's great, except for one, and you couldn't put a for sale sign in the car. And the city was at some pains to try to provide a rationale for this somewhat selective law, and what they came up with ultimately was, we're afraid if people know that the car is for sale, they'll walk out into traffic to get a better look at it, and then they could get run over. So the Court of Appeals bought this argument. As I said, Jeff Rose, in his infinite wisdom, is a newly minted American lawyer from Canada, did not. And so he went to our boss, Chip Miller, who runs the Institute for Justice, and proposed to file what's called an en banc petition. Our federal courts of appeals typically sit in panels of 3 judges. But if you think they really messed up, you can go for what's called an en banc review, which is when the entire court, in this case 15 judges, will get together and rehear the case. That is the legal equivalent of putting a ball in the hoop from mid-court with a blindfold on. Lots of people try it. I've tried it. It almost never works. Jeff pulled it off. And IJ being what it is, you get to basically, we're entrepreneurial. So if it's your idea in your case, you get to see it through. So Jeff Rose's first appearance in court ever as a lawyer was in front of all 15 judges of the 6th U.S. Circuit Court of Appeals, and he won that case 8-7. So the takeaway is that appearing in front of a bunch of Canadian lawyers is kind of terrifying for me because I have this image of them as all being these incredibly intelligent and effective lawyers. I sort of feel like Gulliver, and it's the opposite of being a Lilliputty. Are you guys Brobdinagans? I'm not sure. I was wrestling with that. Anyway, you're really awesome, and I'm really humble, so that's the point there. I want to start by impressing on everybody what the stakes are when we talk about unenumerated rights, and I want to do it by speaking very briefly with you about probably maybe the 2nd or 3rd most disgraceful and despicable policy that my country ever engaged in, and that is eugenic sterilization. We had slavery, we had Jim Crow, which was American apartheid, and I would say that the 2nd or 3rd most disgraceful policy we ever engaged in was eugenic sterilization, which is the compulsory sterilization of individuals deemed to be socially or otherwise unfit so that they cannot reproduce. In the 20th century, we sterilized against their will approximately 60,000 people. As many of you know, bad ideas tend to migrate north, and this idea migrated to Alberta and British Columbia. Alberta actually had a law on the books from 1928 to 1972. They sterilized about 3,000 people against their will. Probably won't be surprised to find out that they were mostly young people, minorities, and women. This is a stain, in my opinion, on both countries, but it raises a very interesting question, and that is whether those people had a natural, unenumerated right not to be sterilized by the government. You will look through the United States Constitution and our Bill of Rights and all of our amendments, and you can look through the Canadian Charter of Rights and Freedoms, and you will not find any specific reference to the ability to reproduce or not to have your reproductive organs ripped out by the government. And so the question arises, does that mean you have no such right? It's an important question. I hope we can agree on that. And I would say that our Supreme Court has done a very poor job of trying to think through this question. I'm going to basically address that as I go forward. But before I do, I want to touch on something I think is one of the most important elements that Canadians and Americans have in common. I asked my friend Jeff, do Canadians think of themselves as being citizens of a free country, and do they take the same sort of pride that we as Americans do? And he said emphatically yes. And then I was reassured that the Canadian Constitution Foundation had this great brochure where it just says right here, it's a free country. So good. I can continue with that theme, apparently. But what does that mean? What does it mean? Why do people take such pride in the idea that they're citizens of a free country? We have this kind of common history that Karen alluded to before, dating back to England and before. But what does it really mean to be a citizen of a free country when, after all, there are any number of laws in Canada and many, many more laws in the United States that restrict our freedom, that prevent us from doing things we might want to do? I've given that a lot of thought, and I think it comes down to this. There are only 2 kinds of countries in the world. I was a Russian major in college when there was still the Soviet Union, so I'm familiar with the other kind, as I am familiar with our kind. But there are only 2 kinds of countries in the world. There are those countries in which the citizens are entitled to a reasoned explanation when the government interferes with their liberty, and there are countries where you are not. And that's what it means to be a citizen of a free country. When the government interferes with your freedom, when it restricts your liberty, you either are or you are not entitled to a reasoned explanation. We are citizens, both of us, of free countries, Canada and the United States, and that means we are entitled to a reasoned, by which I mean honest and adequate explanation when the government interferes with our freedom. I would say that a significant project of virtually every government that has ever existed, or at least a significant project of political science throughout human history, has been for governments to try to revoke, to find a way to revoke or eliminate one of the most basic moral obligations that we have towards other individuals, and that is to give people a reasoned explanation when you impose your will on them. That is one of the most basic moral obligations that we have. And governments, basically throughout history, government has been a series of institutions trying to figure out how to revoke or deny that basic moral obligation. The divine right of kings, for example, majoritarianism, all different theories for essentially saying, look, might makes right, and when I as the king or we the people have decided, we don't have to give you any explanation for why we are preventing you from reproducing or saying that you can't get medical treatment in a facility of your choice, et cetera, et cetera. And this leads to what I think are four of the most disrespectful words in the entire English language. And you're all very familiar with them from when you were children. Because I said so. Get that all the time. We do that to children. I mean, I'm hoping not to, but probably I will slip up. But to say to somebody, because I said so, is to deny their moral agency. It is to deny their entitlement to a reasoned explanation when you impose your will on them. And to me, that really is what most of constitutional law comes down to. Does the government or does the government not owe you a reasoned explanation for interfering with your liberty? And basically, I was going to say there's two answers to that, but it turns out there's actually three. One answer is no, the government gets to do whatever it wants. Second answer is yes, they have to give you an explanation. The third is the answer we've come up with in the United States, which is sometimes they owe you an explanation, but usually not. And I'll argue in a moment that I think that's the worst possible way to go. Of the three alternatives, that is demonstrably and clearly the worst possible way to go, to essentially be in limbo or to be uncertain about whether citizens are entitled to a reasoned explanation when the government interferes with their liberty. The problem with unenumerated rights is this. Most of your rights are necessarily unenumerated. If you took 5 of the most brilliant scholars, put them in a room for a year, and let them just come up with lists of rights, even they would not be able to get most of your rights. It's impossible. It's impossible to list all of the important rights. It's even possible to list a majority of the important rights that people have. It cannot be done. One of the reasons we know this is that in America, our Constitution did not originally include a Bill of Rights. There's a very small handful of individual rights mentioned in the original text of the Constitution, but there was no Bill of Rights in 1789 when the American Constitution went into effect, and this troubled a number of people greatly. In fact, it's one of the reasons why we almost didn't have a constitution and why it almost wasn't ratified. And one of the reasons why it was ratified is that a promise was made that as soon as the U.S. Constitution was ratified and we had a federal government created, national government was created, one of the first things that national government would do would be to discuss the inclusion of a Bill of Rights in the American Constitution. You go back and look at what that discussion looked like, it is incredibly eye-opening because among the things they were doing was debating what rights should be included in the text of the Bill of Rights. And you could see immediately what the problem was, because there are so many of them. And so many people feel differently about which ones you should include and which ones you shouldn't. They were even discussing things like, should we include a right to go to bed and get up when you want to, or go fishing on your own land, eat what you want? These were actual debates and discussions. Someone even asked, I think probably facetiously, but should we include whether you have a right to wear a hat? At the other end of the spectrum, there was even debate about whether to include one of the most fundamental rights that appears both in your charter and our Constitution in the First Amendment, a right of free association. And one of the members of Congress who was involved in the debate over what rights to include in the Bill of Rights strenuously objected to the inclusion of a right to associate, not because he thought there was no such right, but his argument was to include such an obvious, self-evident right would be to denigrate the whole concept of a Bill of Rights. So obvious, why on earth would we put that in there? So you can see, hopefully, the problem. And this problem is inherent in any attempt to list what rights people have, because you will always leave out important rights like not being sterilized by the government. Didn't see that one coming. Anyway, so the way we tried to deal with that in America was that James Madison drafted what became the Ninth Amendment. The Ninth Amendment reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So basically what he was saying was, yeah, we listed some rights, but not all of them, and no one should understand that we did that. In fact, that amendment was adopted for the specific purpose of pretermitting the argument that the only rights that are protected by the American Constitution are the ones listed. And unfortunately, that has become the leading argument for not protecting rights not listed in the Bill of Rights, the very argument that James Madison thought he had preempted with the Ninth Amendment. So he was prescient, apparently, but not effective in preventing that from rising. So the American Constitution recognizes the existence of unenumerated rights. Let me emphasize that again. Constitutions do not grant rights. They either recognize them or they do not. But the existence or non-existence of those rights has nothing to do with whether they're listed in text. Constitutions do not grant rights. They either recognize them or they do not. So our Constitution recognizes the existence of unenumerated rights with the Ninth Amendment, which I just recited for you. And then later in the 14th Amendment, which was added in 1868 after our Civil War. In the aftermath of the Civil War, basically most southern states were essentially trying to act as if the war had never occurred. And the 13th Amendment, which eliminated legal slavery, had never been ratified. In other words, they were continuing to keep newly freed blacks in a state of constructive servitude, simply ignoring their basic civil rights. And the 14th Amendment was designed to empower the federal government, including particularly the federal courts, to prevent that, to eliminate Southern tyranny, not over just newly freed blacks, but over their white supporters and, frankly, everybody, because the 14th Amendment uses the term persons, at least as far as due process and equal protection are concerned. And then there's a third portion of the 14th Amendment that says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, and that is a textual reference to unenumerated natural rights. The Supreme Court had a clever strategy for dealing with the challenge of these textual recognitions of unenumerated rights, which is to ignore them. The Supreme Court has effectively deleted the Ninth Amendment from the text of the Constitution, and it has effectively deleted the privileges or immunities clause from the 14th Amendment. I admit that is a clever strategy. It reminds me, do you watch Saturday Night Live up here ever? All right, there was this bit that they used to do called Deep Thoughts, and this guy would read these ridiculous sayings in very deep, sonorous voice, and one of them that it stuck with me is, even though he was my enemy, starts this way. First he punched me, then he kicked me, then he punched me again. And even though he was my enemy, I had to admit that it was a brilliant strategy. And this is kind of our U.S. Supreme Court, is simply just to ignore text that makes it difficult for you to do your job. And I have to admit, I don't know if it's a brilliant strategy, but it's been an effective one. I want to talk about two unenumerated rights that I'm more familiar with than, thank God, eugenic sterilization, which has, well, let's just say there were some unpleasant events on the other side of the pond that got Canadians and Americans focused on what an awful thing it was. But two rights that I would say are maybe less stark, but no less important, are the right to earn a living. In other words, the right to support yourself through gainful employment and put food on your table, support a family. That's mostly what I work on at the Institute for Justice under the rubric of economic liberty or occupational freedom. And the other is something that Marnie touched on during her talk, which is medical self-determination, or at least that's a term for it. The idea essentially that each and every one of us has the ability to seek medical care to promote our health and, if necessary, to save our lives. Both of those rights are unenumerated. And both of those rights fall squarely within the tradition of liberty and natural rights that both of our countries share. Even Thomas Hobbes, by the way, no huge fan of, or at least not among the most vocal supporters of individual liberty among the Enlightenment thinkers that influence both of our countries' traditions, recognizes a natural right of self-preservation. And the right to earn a living and the right to seek medical care, I would argue, are simply ancillary versions of that basic right. The Supreme Court of the United States has taken differing approaches to the right to earn a living in particular, and I'll walk you through some cases that illustrate the varying approaches that our U.S. Supreme Court has taken, that basically went from not recognizing the right at all, to recognizing it as a meaningful and important right, to continuing to acknowledge the existence of the right to earn a living, but demoting it to a meaningless and insignificant right entitled only to the charade of judicial review, which we call in the United States rational basis review, which is just a fraud and a way of pretending. It's a way for judges to pretend that they are judging in a case without actually doing any judging, and I'll get to that in a moment. The first occupational freedom case that I've been able to identify in the United States involved a law in Illinois that made it illegal for a particular class of persons to be lawyers. And at that time, even though the 14th Amendment was ratified in 1868, and this case went to the U.S. Supreme Court in 1873, the 14th Amendment's equal protection provision was not at that time interpreted to protect discrete classes of people. So that argument, which would be persuasive today, was unavailable at the time. But a member of this class of persons who was ineligible to be a lawyer in Illinois argued that there was a natural right of livelihood and took that up to the US Supreme Court. And the US Supreme Court said, no, not listed in the text of the Constitution, you don't have that right. By the way, does anybody know what this class of persons was who couldn't be lawyers in Illinois? It was women. It was women. And the argument was twofold, essentially, on the part of the government. The government's argument was first that women should be home taking care of children, and second, that women are emotional, and in the presence of a judge, they become incapable of rational thought and advocacy, and they just don't belong in a courtroom. Rather quaint. By the way, has not been my experience. I've been litigating for 20 years. That has not been my experience with women lawyers, if only. I want you to notice something about the second point. That is an empirical assertion. It is either true or it's false. And if we cared, we could ask. And what I mean, a judge could ask. A judge could require some proof that that is true. A judge could put the government to its proof and insist, as they do in some cases, that that be an actual true basis or a real basis for enforcing that law or not. And as I'll get to in a moment, our Supreme Court is quite schizophrenic on this. And in some cases, the government has to be honest and provide support for its position. In most cases, it doesn't. So that's the Bradwell case, Bradwell v. Illinois from 1873. Another case that's quite pedestrian but fun, I think, to talk about involves a humble product that most of you probably have encountered before. It might even be in some of your refrigerators that was banned in a number of jurisdictions in the United States and ultimately by the federal government. And I'm talking, of course, about margarine. Margarine was invented by a French chemist in the late 19th century. And when it got over to our side of the pond, in America at least, you can imagine which industry freaked out. The dairy industry. Dairy industry is a very, very powerful industry in America, probably here too. And they immediately went to state and federal governments to get laws passed to make it difficult or ultimately illegal to sell margarine in America. And one place where that was challenged was in Pennsylvania, where two gentlemen had been charged and convicted of illegally selling margarine. And in defending themselves in court, or in seeking to defend themselves in court, they offered to introduce evidence that margarine is not unhealthy, which was the government's rationale. And the trial court judge did not even allow them to introduce that evidence. In other words, it was completely irrelevant what the truth was. If the government says margarine turns people into witches, or it causes volcanoes to erupt, or it strikes people down with a heart attack the moment you touch it, it doesn't matter if any of those statements are true because the government said so, right? Because I said so. And that went up to the US Supreme Court, and the US Supreme Court, unanimous, no, I'm sorry, it wasn't a unanimous decision. I think it was either 8-1 or 7-2, said, agree. That's correct. If the government says so, that is the end of the inquiry. If women are too hysterical to practice law, none of our business to ask if that's true. If the government says that margarine is deadly poison, that's none of our business whether that's true. All right. So as I said, that changed. And in about 20 years after the margarine case, there was a pretty famous case that some of you have heard of called Lochner, which arose out of a New York law called the Bake Shop Act that made it illegal for bakers to work more than 10 hours in a day or 60 hours in a week. And there were two narratives about the basis for this law. One narrative was the state's narrative, and they said this is a health measure. Working in a bakery is unhealthy. There's a lot of dust in the air. It's hot. And we want to protect people from being exposed to that environment for too long. The other narrative was that this law was lobbied for and passed at the behest of automated bakeries and their union employees who did not need to work long hours in order to produce a lot of bread because they were automated. And it was targeted at immigrants, particularly Eastern Europeans, Italians, and Jews who were showing up in America with very little capital but a hell of a work ethic, and their willingness to try to compete with the automated bakeries by outworking them. And that's exactly what was going on, by the way. And so when it got up to the US Supreme Court, the question was essentially, does it matter which of those narratives is true? And the Supreme Court said, yes, it does. Narrowly, 5-4 vote. And that has been basically the defining dynamic in United States constitutional law since then. Does it matter whether what the government is saying is true, or is the court obligated to simply take at face value what the government says? So in Lochner, the Supreme Court said it matters if it's true, and there followed a period of about, depending on how you count, 25, 30, maybe at the outside 40 years where that was the approach of American courts. And then basically we turned on a dime. In the wake of the Great Depression, we had something called the New Deal, which was an attempt to correct, I can almost not say this without laughing, but an attempt to drag America out of the recession by through a centralized economy and having the government make economic decisions. And that was supposed to be the solution to get us back on the road to financial well-being. I happen to be in the camp that says that actually that prolonged the Great Depression, but put that aside. The Supreme Court initially resisted centralized management by the federal government of the economy. President Roosevelt threatened to add however many justices it took to get them to change their mind. And ultimately that became unnecessary because for whatever reason, the Supreme Court got with the program and essentially went back to some version of its original position, which is we will go back to taking at face value whatever the government says. But it was with an interesting little twist, and that is the Supreme Court allowed people to come in and introduce evidence that a particular policy was irrational, like the margarine or the women lawyers or whatever. It just held that that evidence should be irrelevant. So you can present it, but it doesn't matter if it's true or it's false, because we have essentially an irrebuttable presumption of constitutionality under this thing called the rational basis test that I mentioned a moment ago, whereby the government is not required to give an honest explanation. In fact, the Supreme Court has explicitly held that the government can just make up explanations for its conduct. And actually, believe it or not, judges are required to help hypothesize, that means make up explanations for the government's behavior if their lawyers are not creative enough. And the government need not support its factual assertions in court with evidence. Rational speculation is sufficient. That's the actual term, rational speculation. I've been a litigator for 20 years. I can't wait to get my first case where I'm allowed to base everything I want to do on rational speculation instead of evidence. That is going to be a really easy trial to work up. But anyway, I'd like to illustrate for you the difference between real judging and fake judging by using a case that I worked on. When you litigate economic liberty cases in the States, you have to find the craziest laws that you can because our courts are just completely indifferent to economic liberty. I'm not saying it's a moral failing on their part. They have been instructed to be indifferent by the US Supreme Court. And by that I mean they have been instructed to apply the rational basis test, which is, as I said earlier, just a charade where you get to go into court, challenge what the government's doing, and then the judge just rubber stamps whatever the government wants. So this was the craziest law I've ever found interfering with somebody's ability to earn a living. It was a Louisiana law, which is the only one of its kind in the country, requiring a government license to be a florist. So I'm a lawyer. I'm licensed in Texas and District of Columbia. My sister's a doctor. She's licensed in Maine. If one of us wanted to move to Louisiana and set up shop as florists, we'd have to get a government license to do that. All right. So again, there's two possible narratives here, right? One is the state's narrative, which it actually offered in court, which is this is a consumer protection measure, trying to protect people from poorly made flower arrangements and the physical dangers of unlicensed floristry. You laugh. Imagine trying to keep a straight face if you're the government lawyer and saying that in court. The other possible narrative is this law was passed at the behest of the Florist Association, which is actually quite powerful in Louisiana, so that they don't have to compete with newcomers, possibly highly skilled newcomers from other states that are much better at what they do, possibly. Okay, so those are the two narratives. I'll skip over the litigation, which was quite humorous. I got to depose members of the Louisiana Horticulture Commission and invite them to speculate about why the law was enacted. I got things like misplaced corsage pins and exploding wedding bouquets. I thought that was funny until the judge upheld the law on the basis of misplaced corsage pins and exploding wedding bouquets and, my favorite, infected dirt. I have no idea what that dirt was infected with, and I have no idea how licensing florists would help mitigate that problem, particularly since they don't test on infected dirt. But again, it's rational basis review, so the whole thing's a charade from start to finish. Now, that's fake judging, and that's most of what we do in America, because rational basis review is the default setting. The Supreme Court, in its infinite wisdom, bifurcates our constitutional rights into two categories: fundamental rights, which is a very tiny little category, things like free speech, religion in some cases, the right to travel, raise your own children. That's a fundamental right. You go into court, you're going to get a real engaged judge. I'll explain what that means in a moment. But generally speaking, virtually all of your rights are considered by the Supreme Court to be non-fundamental, including your right to earn a living and seek medical care. And so you're going to get the charade of rational basis review, which I just described. Well, what does real judging look like? What does it look like if you actually are able to litigate a fundamental rights case? Well, I've done that, so I can tell you. Imagine if Louisiana had, instead of restricting who can work as a florist, instead restricted who could advertise their florist business. So anybody can do it, just like in all the other states. But you have to have a special permit from the government to advertise your floral shop. Well, now you would have the Supreme Court's attention because that's a free speech case. And the Supreme Court considers free speech, including advertising, to be a fundamental right. And that's where you get real judging or judicial engagement. And what that means is a genuine quest for the truth about the government's means and ends by a genuinely neutral adjudicator, not somebody who's trying to put their thumb on the scale for government, on the basis of evidence and not speculation or conjecture. Okay, so how does that look in real life? Well, it's very simple. Government comes in to defend the advertising restriction. The judge says, what's the problem? And the government has to do something incredible in constitutional litigation. They have to tell the truth. Wow. And they have to tell the truth about what the problem is. They have to tell the truth about how they're trying to solve it. They have to have some evidence that the problem really exists and that the means they've chosen to address it will in fact mitigate the problem. And then they have to prove that there was not some less restrictive way that they could have gone about it. So if floral arrangements are really a problem, perhaps you could have a disclaimer. We do that for cigarettes and alcohol. Why wouldn't that work with flowers? Anyway, so that's real judging. That's what it looks like when a court is trying to hold the government to its constitutional obligation to provide a reasoned explanation in all cases. And it is the exception in American jurisprudence, not the rule. I want to touch on medical self-determination very quickly because I want to leave time for questions. It's not a very advanced area in the States. In fact, we really don't have any Supreme Court case law directly on this question. But the most, I would say the most prominent case that we have comes from the court right below the US Supreme Court, the DC Circuit Court of Appeals, which handles a lot of litigation against the federal government, including policies of federal agencies like the one I'm about to describe. Long story short, as many of you probably know, we have a very complex and cumbersome drug approval process in the United States overseen by the Federal Drug Administration, the FDA, and it can lead to very effective and useful drugs not coming on the market for many, many years, decades even. And that happened in a case involving some terminally ill cancer patients for whom no other therapy or form of treatment had worked, but whose doctors all told them that there was a particular drug that was going through approval process with the FDA that might save their lives. So they went to the FDA and said, we'd like a waiver, we'd like access to this drug, and our doctors tell us it's the only thing that might save our lives. The FDA did what bureaucrats typically do in this situation and said no, without giving any real explanation. And so the patients went to court, and they challenged the government's refusal to give them access to these potentially life-saving drugs on the grounds that the ability to save your own life by seeking medical treatment is a fundamental right that the courts should take seriously. And the DC Circuit, sitting en banc, I described that process earlier, rejected that argument and said no. 8-2, they said no, there is no fundamental right to try to save your own life, even if you're dying of cancer, by gaining access to an experimental cancer drug. And here was the kicker. Guess what the rationale was? The FDA is just trying to protect your safety. Yeah. Because you're dying of cancer. And they're protecting your safety by making sure you don't have access to these experimental drugs. That's insane. Even under the rational basis test, which is what the government or the court found should apply, that policy should fail because it is insane. And that shows you how completely watered down and meaningless the rational basis test really is. It is a charade, it is a sham, and it's a fraud. But it enables the court to go through the motions of judging in all constitutional cases, but then without actually providing any of the substance, without actually having to do the hard work of analyzing claims, of determining if the government's telling the truth, and not to put too fine a point on it, of essentially grading the legitimacy of the legislature's product. Were you acting for genuinely public-spirited motives or for nefarious purposes, like the Louisiana legislature clearly was by regulating florists? Were you regulating with some care, as opposed to just some blanket policy like the FDA's that results in terminally ill cancer patients not having access to drugs? So, to recap, unenumerated rights exist. You can't deny it. Basically, every intellectual who contributed to our common heritage, the Enlightenment theory or tradition from which both of our systems of democratic government emerged, believed in natural rights. They designed government systems around the concept of natural rights. So to try to operate that system as if they don't exist is like trying to run an internal combustion engine without a carburetor. It can't be done. And the only remaining question is whether your judiciary is going to take an intellectually honest approach to identifying and protecting unenumerated rights, or an intellectually dishonest approach in which they engage in fake judging and pretend to go through the motions of judicial review while providing nothing of the sort, which is what we've been doing for the past 50 years. Should that bad idea ever make its way up across the border, I encourage all of you to reject it out of hand. Thank you.
Hi, that was a really interesting presentation.
Thank you.
When you're talking about the rational basis for judges making decisions and rubber stamping government approval,
Yep.
When the Affordable Care Act was being debated and when it was passed in Congress, the president and members of government said it's not a tax.
Right.
And then when it was challenged at the Supreme Court said it is a tax.
Yeah.
Was that an example of this rational basis?
Yes, yes. So for those who aren't familiar, in the American system, we have enumerated powers for the federal government. There's only certain things the federal government has been constitutionally authorized to do, and Congress is constantly trying to push that envelope. And one example was the requirement that was enacted into law in 2010 under the Affordable Care Act that requires all Americans, with certain exceptions, to purchase government-approved health insurance. And the question was whether the federal government had the authority to enact that law, and the Supreme Court held that the government did have that authority under its power to tax people, because it was essentially what they argued was that if you fail to get the government-approved health insurance, then you have to pay a higher tax rate than if you had purchased it. I'm sorry, what's your name?
Ash.
Ash. So as Ash pointed out, this was an interesting ruling at best, because both President Obama and the Democratic leaders of Congress who had urged the law had repeatedly denied that it imposed any new taxes. And then the Obama administration turned around and argued in court, no, actually it is a tax. So there was a bit of a non sequitur there at a bare minimum. But yeah, and rational basis review applies to federalism questions. That's a federalism question. And so that's a perfect example of how rational basis review works in real life, which is you start off with the end in view, which is we're going to uphold this law, and then you just work backwards from there. And that's a great example. No one, by the way, that I know is persuaded in the least by that opinion Justice Roberts wrote, Chief Justice Roberts. And in fact, the law in question never once refers to the extra payment you have to make if you don't have the insurance as a tax. It refers to it as a penalty 18 times. Chief Justice Roberts rewrote that language. Penalty was changed to tax. That is not something our courts are supposed to do, by the way, rewrite legislation. Why did he do it? Because the case was a foregone conclusion. It was a rational basis case, which means the government wins, and the only question is how do you work backwards from there? Yeah, great question. Thank you.
Hi. You used some very strong language in describing the government's position in sham, fraud,
Yep.
So on. You described some of the court decisions in very unflattering terms and very bluntly. And I just wanted to know, as a strategic matter, is that the way you actually speak in court, or are you more deferential? Because, I mean, to me, what you said makes absolute sense, and I just wondered whether you've ever actually gone and said those things to a court.
No. Let me answer the question with an anecdote that I shared with a couple of people at lunch. I litigated an economic liberty case in my home state of Texas, where I originally started practicing, and it was a fascinating case involving this weird profession where you file down horses' teeth. It's called horse teeth floating. Horses' teeth grow throughout their lifetime. They have to be filed. The question in Texas was whether that could only be done by veterinarians or by non-veterinarians who happen to be really good at it. So our lead plaintiff was the king, and literally he was called the king of this occupation. And he wasn't a veterinarian, but he was so good that when veterinarians had problems they couldn't solve, they called him in. So he's my lead witness. I put him up on the stand we had a hearing that was very much like a trial, and it was awesome. He's got a horse skull. He's got his equipment. He's showing how the equipment works in court, and I'm leading him through his testimony. I look up at a certain point, and the judge his eyes are glued to the computer monitor on his desk or his bench. And during a break, I asked the court reporter, because I used to practice in Texas, so I suspected what might be going on. I said, is the judge, are you generating a real-time transcript and he's reading it? Because I know some people take information in better by visually. And she said, no, he's surfing the internet. So that's an example. That's a metaphor. It's a visual metaphor of judges in rational basis cases. And of course, the answer is no. I can't say the things in court that I'm saying now. I think them, but I have to play along. And treat the standard as if it actually means something. And we do that in a way that reflects, I think, a litigator's mentality. But I have decided within the last few years that this issue is too important for me to pretend outside of court like there's a shred of integrity to the rational basis test or to the larger doctrinal framework in which it figures. And I am perfectly aware that that means I will never be nominated for any position requiring confirmation by the United States Senate, including a judgeship. And I'm perfectly aware that that might be thrown in my face the next time I'm in court. And I'm willing to accept that. But I think we all have to make a choice at a certain point if you're going to go along with something that you believe to be morally and intellectually indefensible. I'm not. Yes, I have to parrot the right words in court. But when I'm not in court, I'm going to tell it like I see it. Thanks for the opportunity to say that.
I have two questions that sort of go together. The first one is historical, and I'm not an American, but my understanding of the 9th Amendment, because we have an equivalent in Canada, Section 26 of the Charter, and my understanding was that really what that was saying was that, well, we're not saying these rights don't exist, that we're not enumerating. So under the common law, no one could ever say, well, you no longer have this common law right, because if you did have it, it would be in the Constitution. And so that they weren't acknowledging that these were constitutionally protected rights. They're just saying we're not abrogating them in the common law. Right. And so that's my first question. And my second one is that even if we do acknowledge that there would be unenumerated rights based on natural rights, how do we discern the content of those rights? Which natural rights should be protected, which shouldn't? If we appeal to history or original intent, you know, I'm sure we'll get a good list of classical liberal rights, but we'll probably also get rights that we don't want. That, you know, a lot of the framers probably believed in a natural right to slavery, and they certainly didn't believe women were included in those who possessed some of the natural rights. You know, could someone argue that there's a natural right to abortion or to certain forms of marriage that other people disagree with? And then do we want to leave it to judges to determine the content of those rights?
Thank you. Those are excellent questions, and give me an opportunity to say some things I wasn't able to address in the first 30 minutes. Tell me your name.
Asher.
Asher?
Another Ash.
Is everybody Ash? Okay, that makes it easy for me. So I think the first part of your question is essentially Justice Scalia's position, one of our Supreme Court justices, that the 9th Amendment recognizes the existence of certain unenumerated natural rights, but that doesn't give courts any basis for enforcing those rights. I think that's absurd. A right without a remedy is not a right. And the 9th Amendment specifically says that rights not enumerated in the text of the Constitution shall not be denied or disparaged. And to say that some rights may be protected meaningfully in court and others may not, I can't think of a more stark way to disparage a right than to say that it cannot be protected, but this other one can. So I reject that. I think it's a ludicrous response, and I think it's one that James Madison would have found ludicrous as well. And he would have chosen different language, much different language, if he had meant to convey that. The second question is, what are your unenumerated rights? And yes, I mean, if you frame it that way, it's a challenging question. Let me ask you a question. Do you think you have a right to eat a sandwich so you can stay alive today and sustain yourself? Yeah, sure, of course. Can it be a peanut butter salad sandwich? No, I'm serious.
Yeah, no.
Okay,
I mean,
well, can it be an alfalfa sprout sandwich?
I just
see, now I'm making you play the game that you try to make me play. And I'm not being confrontational. I am, but I don't mean to be confrontational. I consider this project. I resist this. I do not. I think it's a fool's errand to allow yourself to be put in the position of saying, well, okay, I can give you a list. Yeah, it's this, that, and the other thing. The idea of natural rights is much different than that. They're not granular. It is not a right to do this, and then a right to do that, and a right to do that, or else you get trapped in that whole sandwich example. Oh yeah, no, ham is okay, but not beef. Instead, you have a natural right to do what you wish, so long as you don't violate the equal right of others. And it is incumbent upon the government to make a sufficiently persuasive case that in a particular instance, you shouldn't be able to do that one thing. Kill an unborn child, maybe. That would be a response. You know, I solicit clients on the street. I'm not persuaded by that one, but at least, you know, they attempted to make a reasoned argument for that policy. But what I would say is this. My view is that it is always incumbent upon the government to first identify the source of its authority to impose its will on me, and to say candidly why it is restricting my freedom, and not lie in court like Louisiana did when it came in and said, oh, we license florists to protect the public. And once the government has discharged that obligation, then it may be incumbent upon me to identify some source of textual authority for the proposition that I have a right to engage in the conduct. But I don't play that game. I don't allow people to come to me and essentially say, oh, it's incumbent on you in all cases to find a textual source of your liberty to do X, Y, or Z. Because I'm going to admit right off the bat, there is no textual source of my liberty not to have my reproductive organs ripped out, or my ability to go out and earn a living and put food on my table and my family's table. I'm not going to play that game. And James Madison said, at least in the American tradition, I don't have to. By the way, so did John Locke. Thank you for the questions. I appreciate it.
First, thanks for an absolutely awesome presentation. Really appreciated that. Quick question. A great deal about rational basis. I'm wondering if you could quickly first part of the question, what is required to get beyond rational basis? And two, once you've cleared that hurdle, what is the standard that is being applied? Now, the reason I ask is last time I had any consciousness of this, which was a while ago, the Supreme Court was using strict, intermediate, and rational basis. Is that still in effect?
Yeah, okay, so great. What does it take to get out of the rational basis box? The answer is you have to convince the court that you are dealing with either a fundamental right. As I said before, Supreme Court bifurcates our rights into fundamental and non-fundamental. So you either have to convince the court that you're dealing with a fundamental right, and they've used various tests for that, but the current one is that it is deeply rooted in the American tradition, I can't remember what the second part of it is. It's all kind of meaningless.
Or
anyway.
Classification.
And the second question, if you can't convince the court that you're dealing with a fundamental right, then the other way to get out of the rational basis box is to convince the court that the government is discriminating on the basis of what we call a suspect classification, of which there are a handful: race, gender, religious faith. What's that?
Alienage.
Alienage to a certain extent, although that gets a lower standard than, for example, race. So that's how you get out of the rational basis box. The question of whether the court's applying different standards when you get out of there, absolutely. There's all these interesting debates among common law professors of how many other standards there are. In the book that I wrote, which I guess I'll shamelessly plug now, Terms of Engagement, as Marnie said, available on Amazon, it doesn't matter. Because there are only two really meaningful standards of review in American constitutional law. There's rational basis review, which is fake. That is a standard where judges avowedly abandon the truth-seeking function. And there's what we call heightened scrutiny, where heightened is simply a euphemism for real or genuine, where the court asks the government, what are you really doing? Do you have evidence to support the factual assertions you've made in my court? If those questions are being asked by the judge of the government, then you are by definition dealing with a heightened scrutiny case, and it doesn't matter whether it's intermediate, strict, or anything else, because 9 times out of 10 you're going to win because the government doesn't have a shred of evidence to support what it's doing, and it didn't go down this path for any good reason. At least that's my experience as litigator. In fact, if they find themselves suddenly in a heightened scrutiny case, more often than not, I wouldn't say more often than not, but many cases the government will simply give up because they realize if the case is going to be decided on the basis of truth and evidence, they are going to lose, and they will just walk away. So they really want to be in that rational basis box where they get to lie and dissemble and base their policies on speculation and conjecture. And, as I said before, our Supreme Court has been kind enough to say that that's our default setting, and that's where the government will be in most cases. As you can tell, I object.
Thank you very much.
Thank you. Thank you.
Thanks, Clark, for coming up today and judging on what I looked at your book. I think I agree with you on the kind of government I'd like to live under, and I certainly agree with you that the Supreme Court and really all the U.S. courts have pretty much abdicated certainly their role as neutral arbitrator of federalism issues since 1937, and by and large checked out of economic regulation as well.
I'm sorry?
And abandoned any meaningful scrutiny of economic regulation as well since the New Deal crisis. Right. So I'm a friendly questioner here, but I would challenge you on this. If you agree that there's almost an infinite number of non-enumerated rights, and you agree that almost everything government does, not just in economic regulation or work regulation or tax regulation or environmental regulation or tax law, everything, makes distinctions and infringes on our freedom.
Yep.
If you want to push everything into the strict scrutiny category,
which I don't,
well,
just heightened scrutiny.
Well, that's interesting you're saying that now, because I think most people in the room would have thought, like I've thought, that you want to push everything into the strict scrutiny. Would you have to increase the size of the federal judiciary by, 3, 5, or tenfold? And would you not, in fact, be transferring an awful lot of the work that state legislatures and Congress does out of the legislative assembly and into courts? And could be a boon for us social scientists, right? We'd be pumping out all those studies that you'd have to use,
right.
The Section 1 stuff that was referred to earlier by Dennis.
Right.
I think there's some practical problems with what the implications of what you've said. And then secondly, I just say to the Canadian students here, one of the reasons, I'd say in the 50s, 60s, 70s, that there was quite a bit of support in the Canadian legal community not to go down the American path of a written bill, Charter of Rights and judicial review, which of course we did in 1982, was precisely the idea that there were all these important natural rights, many of them embedded in common law, but that the courts didn't have a monopoly on defending them. And you can actually go back and look at quotations. We're saying precisely because these rights are so important, we want to keep them under the purview of elected governments, not unelected judges. So a little footnote to Canadian history.
I appreciate that. So let me clarify first what I'm arguing for and what I'm not arguing for. As I tried to make clear in my response to the last question, as an American constitutional litigator, I am firmly persuaded there are only two standards of review in American constitutional law that matter. There's rational basis review, which is fake, and there's everything else, which is real. I don't care if it's intermediate scrutiny or if you want to call it rational basis with bite, which is a term of art, as you know, or strict scrutiny. I don't care what it is. If it's heightened scrutiny, meaning something other than true rational basis review, I'm a happy man. I'll retire to a beach somewhere and let my colleagues clean up the rest. Second point, will the courts suddenly have to expand by tenfold? Well, there's good news on that front. Well, first let me preface it by saying this. I was one of the lawyers that brought the DC gun case, for those who are familiar with District of Columbia v. Heller. We have a Second Amendment, which I know is quite controversial, but it exists. Says that the right, a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. That right lay dormant for 200 years. I and two other people filed a case to try to revive it. It worked. The Supreme Court said 5-4, the Second Amendment actually protects an individual right. One of the first things people said, both before and after the case, oh, we're going to have so much gun litigation. We're going to have, courts are going to be so much more busy. Guess what? Up until 1920, the U.S. Supreme Court found that the First Amendment was essentially meaningless as well. Didn't protect a right of free speech in any meaningful way or a right of religion in any meaningful way. When people started litigating those rights, the exact same point was made. Oh, the courts are going to be so busy if we protect speech. Well, perhaps, but that's what they're there to do. That's their most sacred constitutional duty, at least in America. And the good news, by the way, is that if we eliminated rational basis review and the government had to make an honest case for all of its laws, most of our drug laws would go away and the courts would have a lot of free time. So it's almost a beautiful symmetry there. And the last point I guess I would make is that this is a matter of political science, and I'm not here to tell you that I'm right and you're wrong, but I think you should think long and hard about who should have the final say. I reject the term supremacy or constitutional supremacy. It's a much more narrow question. Who has the final say on whether the government is violating your constitutional rights? I think there can only be one answer, because if it's not the judiciary, and you let that decision be made by the people who are doing it, by the people who passed the law you're objecting to, or the people who are enforcing the law you're objecting to, you are violating what may be the most fundamental maxim of justice that has ever been discovered by mankind, and that is not allowing a person to be a judge in their own case. You do not ask somebody who wants the last slice of pie whether that's a just decision, because they want the last slice of pie. You bring in a neutral arbiter to make that decision. That's the role that our courts serve, and to leave that decision to the branches that are themselves inventing and implementing the laws that we push back against is, to me, again, a violation of a very fundamental maxim. So I reject that, too. I reject everything. I'm off to the airport. Thank you very much. I appreciate the time.